Breaking news. Recently, the name of fashion icon and well-known entrepreneur Datin Vivy Yusof was hotly debated and became a target for nonsense when she was accused of questioning and belittling the assistance given to the B40 and M40 groups through the economic stimulus package announced by the government. Following that, a petition was also made against Vivy demanding that she resign as a member of the board of UITM. Now, let's see what Vivy Yusof has to say.
Also be taking legal action on these people that started the rumors, started the lie, started the petition. It's just so mean, so vicious, and so unthinkable how you can do this to someone. So I think what I want to say is that I apologize once again to netizens and masyarakat B40. But I want to tegaskan yang saya tak pernah pandang rendah siapa-siapa. Kalau saya pandang rendah, memang saya takkan peduli langsung. But I care. I think my actions speak louder than words. I care. And yeah, I hope you can see through that and not just believe everything you read on Twitter.
There's no way he did that. Calm down, Vivy. We'll bring this case to our boss. We'll see what we can do.
Assalamualaikum to our boss. My name is Aliyah. Together with me is Ala and Aisha. And we have an interesting news that we think our firm can take on. For starters, we will go through the summary of the news, then our chosen course of action, and then our legal issues, and lastly, the comments and opinions. As we all know, during the first MCO in March, the government gave money or Bantuan Prihatin Nasional to SMEs B40 and M40 to support their lifestyle during these trying times and to support small businesses. There were a few discussions on SME and large enterprises, which our potential client, Vivy Yusof, shared some on her Instagram page. Next. As a result, it sparked some conversations under her comment section. A friend of hers, Alia Zainal, commented saying, I think the poor will become richer during COVID-19 and jobless after. Businesses like us are trying our best to survive. Like you, I'm sad to hear some of my friends have to close down their businesses. Can't afford to pay. Then Vivy responded saying, exactly. It's short-term relief and huge suffering later for everyone from businesses to employees. Her response of exactly went viral. This caused a commotion online accusing Vivy of belittling B40 and M40 groups and downgrading the poor. 2 days after her comment, a petition to remove Vivy Yusof from the board of directors of University Technology Mara was made by the Alumni Association of UITM, a man named Mazlan. So the petition includes a description in Malay saying, number 1, many families of UITM students are those from the B40s and M40s. Number 2, Vivy Yusof and a friend condemned the government's action of giving money to B40 and M40 families during the pandemic by saying the poor will get richer. And number 3, Vivy does not carry her responsibilities of the board of directors and not holding the UITM name well by supporting the comment on section on social media that affects the families of B40 and M40. Number 4, she is not an economist, and number 5, she is not a scholar intellectual. So these are the comments that Mazril said to Vivy. But then the petition posted on change.org has now closed, receiving 35,000 signatures. Then Vivy denied ever saying the words "the poor will get richer" and that people misunderstood her response. This post explained herself in that situation. She meant exactly to how sad they have to close down businesses and not exactly to how the poor will get richer. Overall, she is not in support of such a statement. On top of that, Vivy made a 7-minute video apologizing for the people who took her statement out of context. Next. And she explained what happened in this Instagram post. So, what can we do?
So we would like to initiate a legal cause of action of defamation by representing Vivy Yusof. The tort of defamation protects the person's good name and reputation, especially if the defendant had made an untrue statement or what amounts to a statement which is defamatory of the plaintiffs, and so the plaintiff has a right of action against him. There is no proper definition of defamation as it has not been defined in the Malaysia Defamation Act 1957. However, we can find the definitions in case laws. For example, Winefield and Jolo Wiss, they define defamation as the publication of a statement which reflects on a person's reputation and tends to lower him in the estimation of the right-thinking members of society, generally, or tends to make them shun or avoid him. So there are two types of defamations that we need to know, which is libel and slander. So libel is a defamation in a permanent form, usually visible to the eye, such as a comment, a letter, or on a defamation on a website. So it is actionable per se, meaning that you don't need to prove damage as it's already assumed that damage will result. And then for slander, slander is defamation in a temporary or transient form. So it's through spoken words or gestures, and this is not actionable per se, as the plaintiff needs to prove actual or special damage in order to succeed in his action. So as we can infer, it is plain and obvious that in our case, it falls under libel as it checks all of the boxes here. So in order to bring a cause of action in defamation, there are three criteria that need to be proved and established by the plaintiff. So first is the first element, which is that the words are defamatory. So the words can be defamatory in three ways: natural and ordinary meaning, innuendo, and juxtaposition. So natural and ordinary meaning is just the literal meaning of the words. Innuendo is used to describe words which have special meaning only to people who have knowledge or of some special background or facts, and juxtaposition is the fact of two things being seen or placed close together with contrasting effect. The second element is that the plaintiff needs to prove is the words refer to the plaintiff, and thirdly is the words have been published or communicated to a third party. So these are the necessary issues that we need to establish and prove in order for us to bring a cause of action for Vivy. Firstly is whether the words in the petition by Mazlan were in fact defamatory, whether the words written by Mazlan refer to Vivy Yusof, and whether the words published by Mazlan was published to a third party. So moving on to the first issue is whether the words in the petition by Mazlan were in fact defamatory. So the first main case that is going to lend support to our case will be Dr. Clarence, Edwin, and another, and Harta Kampulan, Sundarian Berhad, and another. So the facts of this case is that this was a suit for libel, whereby the plaintiff one is an advocate and a solicitor, and the second plaintiff is the legal firm where he used to work at. So the defendant in this case was a private limited company carrying on the business of property investors and developers, while the second defendant was one of its directors. So before this case arose, there had been a previous civil suit between defendant number one and IGM corporations, whereby the results had not been favorable for defendant number one. So IGM were the one who won that suit. So plaintiff one, during that time, he was actually employed to be and to represent IGM in that said civil suit. So the defendants had then published the letter concerning plaintiff's one conduct as IGM's counsel, which was alleged to contain defamatory words referring to plaintiff one, Dr. Clarence, without any factual basis being shown. So the letters contain a barrage of personal attacks against plaintiff one. The impugned words in the letter, so far as they relate to plaintiff one in their natural and ordinary meaning, were alleged to be understood to mean that number one, he is unfit to be an advocate and solicitor of the High Court of Malaysia. Number two, he is unprofessional, malicious, vindictive, and lacks integrity. Number three, he is a liar, cheat, and has committed deception. And lastly, he has committed an offense punishable under the Penal Code. So the defendants in this case, they had published the libelous letter to unrelated parties. So they published this letter to not only the authorities, but also unrelated parties, such as CEOs of banks, insurance companies, and members of the judiciary. Defendant two even admitted of authoring and signing this letter, as well as its wide publication. So plaintiff one had then brought a defamatory action against the defendants. So the issue in this case arose, which was whether the letter published by the defendants amounted to defamation towards the plaintiff. And the judgment in this case was that the defendant's actions of publishing the letter does amount to defamation towards the plaintiff. So the reason behind the court's decision in the Dr. Clarence case is, first thing that they did in order to see whether the words are truly defamatory is known as the test of defamatory words, which is a really important test, which is whether such words were calculated to expose the plaintiff to hatred, ridicule, or contempt in the mind of a reasonable man, and or would tend to lower him in the estimation of right-thinking members of society generally. So from the authorities, it is settled that for a cause of action in libel to succeed, as we have previously mentioned, there are three vital ingredients that needs to be established. Number one is that the statements have to be libelous or defamatory. Number two, the statements refer to the plaintiff. And number three, that there was a publication of the statements. So in this case, when they used the defamatory test, they found out that there was no doubt that all the impugned statements made against plaintiff one, Dr. Clarence, were capable of being defamatory and indeed bore defamatory imputations against him, as they truly ruined the reputation of the plaintiff, and it created the general society to avoid and shun him, especially since he is an advocate and a solicitor. So that affected the people to not hire him as their advocate. So another point that we want to, in the case of Dr. Clarence that they mentioned, was that the writer, defendant number two, was accused by deep malice in writing the letters, and it spoke for itself, because he did not miss the opportunity to discredit and defame the plaintiff. Moreover, the fact that there was a deliberate publication to a variety of persons appeared to be a planned and calculated move to cause optimum damage to plaintiff one's reputation. He seemed serious and willing to publish the malicious words to all and sundry in blatant disregard of subsisting injunctions prohibiting him from doing so without any factual basis being shown. So in the Dr. Clarence case, they have also stated the two other elements of defamation, which is that it must refer to the plaintiff and that there was publication of the statements. However, these two will be later discussed by my colleagues. So we added an additional case, which is Dato Anwar bin Ibrahim and Utusan Malayu and others. So the case facts for this is that the plaintiff, Dato Anwar bin Ibrahim, he claimed for damages against the defendant for allegations of two libelous articles published by the defendants who are a local newspaper. So the two alleged defamatory were supposedly based on the statement of the plaintiff in a BBC interview, whereby Anwar said that the Malaysian legislation on homosexuality should be reviewed. Yet in the defendant's local newspaper, they published libelous articles on it saying he wanted homosexuality to be legalized, which he denied ever doing so. Next. So now we are going to be applying those rules that I just mentioned. So the first step for the first element to figure out whether the words are defamatory in nature is the test of defamatory words. So there needs to be two effects, which is number one, it has to lower Vivy reputation, and number two, it makes the society avoid / shun her. So this is we have to extract firstly the statement made by Mazlan in the petition, and this is what he has said, and we are gonna translate it into English. Next. So here are the words used by Mazril in the petition in English. So before we actually head into the test of defamatory words, we need to identify in what way are the words defamatory. As we know, there are three ways which are natural and ordinary meaning, innuendo, and juxtaposition. So for us, we have derived to the conclusion that all of the statements that he have made are defamatory in their natural and ordinary meaning, which is similar to the case of Dr. Clarence, where the accusations against him were clearly defamatory in its natural and ordinary meaning. The words used in the petition concerning Vivy were also definitely defamatory in its natural and ordinary meaning. Okay, so now that we have identified what type of defamatory word it is, we then move on to the test, as we stated earlier. So we have extracted his statements, and now we're going to go through them one by one and apply the test for defamatory words. So the first statement that we have extracted is Vivy and her friend Aliyah Zailan have slammed the government for aiding the B40 and M40 community who were extremely affected by the outbreak by saying the poor will become rich. So the words above, in its natural and ordinary meaning, states that Vivy is attacking the government for helping the B40 and M40 community. These words imply that Vivy does not care about the B40 and M40 community, as she is apparently opposed to helping them. So now applying the effects, the test of defamatory words, the effects of these words cause the B40 and M40 community to dislike and distrust Vivy. It shows her as someone who lacks compassion and respect. She is portrayed like being arrogant and not caring about the government's support of the B40 and M40. In turn, this lowers her reputation in the public's opinion in general, as she was at that time on the UITM board of directors that deals with aiding the B40 and M40 community. Her role on the board, contrasting with such insensitive words, paints her to be a fake person who tricks others into giving her the responsibility while hiding her true sentiments. On top of that, Vivy being a well-known public figure, being a well-known public figure, she would definitely be astonished and would feel ashamed by these defamatory words, especially when she totally rejected them and indicated that she did not mean any such kind of negative impact on people whom she used to support and help. And the next statement that we've extracted is that by Mazril, which is she failed to carry out her duty as a board member of UITM. In fact, she didn't keep intact with the university's reputation by supporting the bad actions done by her social media friend. So the words in its natural and ordinary meaning states that Vivy was incapable of carrying out her duty as a board member of UITM. It also said she failed to protect UITM's reputation and that she supports bad actions done against it. So now applying the effects, the test is that the effects of such accusations implies Vivy is incompetent and too irresponsible for her position as a board member, accusing her of being passive when bad actions are done against UITM. Also implies she does not care about UITM's reputation despite being a board member. This once again shows her as someone irresponsible and not deserving of her position. It lowers her reputation in the public's eye as she is seen as someone clever who managed to gain a position despite not being qualified for it. This also might consequently erode the reputation of Vivy, leading to people avoiding her and shunning her, causing loss to her business. And the third statement by Mazlan is she's not an expert in economy. The words in its natural and ordinary meaning states that Vivy is not qualified in economic matters, despite her having a role in providing financial help for the B40 and M40 community. By applying the test, we can see that the effect of this statement is that it makes the public think she should not be in her position as a board member of UITM. It encourages them to remove her from her position. It also discredits her knowledge in economy and implies that she had not deserved the role in the first place. This has the effect of lowering her reputation as a member of the board of UITM. The above defamatory statement also reflects the intention of Mazril to show Vivy as someone who is not of knowledge and qualification to delve into economic matters, despite her success in managing her own business. On the other hand, this statement might change the perception of the public about the previous image of successful Vivy to ignorant one, especially in matters of economy. And lastly, the last statement that he had said was that she is not a scholar. The words in its natural and ordinary meaning states that Vivy is not a smart person. And applying the test, the effects of this statement is that it lowers the public respect for her opinion and words. It reduces the weight of her influence on the public and encourages them to pay less attention to her inputs. It implies Vivy is undeserving of her role as a board member of UITM since she is not a smart person. On top of that, this can affect the renewal of her contract as a member of the board of directors in UITM. It encourages the public to want her to remove her from the position as a board member, saying this is belittling and demonizing the personality of Vivy and her competency to argue in such issues of public interest. It also creates other people in the business to not want to work with her and start previous slide please, and would start to avoiding her. In other words, it's like he is saying you are not a scholar, then you're not qualified to give an opinion. One might also infer that raising the question of she is not a scholar shows a self-interest to remove her from the board of directors in UITM, especially when we find out later that he is actually an alumni of the university and he knows the ins and outs of the university. So perhaps he has some sort of self-interest in defaming or tarnishing the image of Vivy for certain purposes he knows better. So now that we have looked at the effects of the words, we can clearly see that the test has been established. The words firstly lower her reputation in the right thinking of society, the society's minds, and that it makes people avoid and shun her. But furthermore, the action of Mazril to start a petition against her amounts to defamation, as he did not establish facts about her real intention and opinion. He just rushed to the petition, which brought the whole case to public attention without establishing facts or researching or maybe even communicating with Vivi directly to see that whether this is her true intention and if this is what she truly meant. This move caused Vivi to become in the negative spotlight of the public, tarnishing her image and reputation in the public opinion. Similarly, in the case of Dr. Clarence, whereby the defendant he published the letters without any factual basis being shown. So, applying the case of Dato Anwar bin Ibrahim and Utusan Melayu, it can be partly applied to Vivi case, especially in terms of diverting the information and taking them out of the context to cause damage to the reputation and image of the person. Similarly, in Dato Anwar's case, the defendant had been the one who changed his words, stating that he wanted to legalize homosexuality when he just said that they should review the homosexuality laws, even though he even expressly mentioned that he never even said that and he did not mean that. This gravely affected and had the effect of lowering his reputation and causing people to avoid him. Taking this case, we can also see that Mazril tried to twist the statement of Vivi and tried to divert it to mean that she is against the B40 and M40, despite her saying that she did not intend that and does not mean to belittle the efforts of the government in helping these groups. She is also one of the people who used to help them and support them in her own business and work. So in conclusion, by putting all of this together, it shows the words are defamatory on the side of Mazril towards Vivi. It can be concluded that the words used in the petition were definitely defamatory. And by that, the first element of defamation has been established.
Okay, so for the second element, is to prove whether the words written by Mazlan were referred to Vivi. We can observe the judgment from the case Tan Sri Datuk Vincent Tan Chi Yuan and Haji Hassan bin Hamzah and others, 1995. In this case, the defendants published in an August 1993 issue, which was written by the second defendant, with the heading Vincent Tan's Media Foray. The article contains the sentences that implies the plaintiff wanted to use the press for his business advantage. The plaintiff established the Sun, but he was not getting contracts from the ministers. The plaintiff scolded the editors as to not criticize his friends. The seventh defendant entered innocent publication. However, it was held to have failed because two conditions had not been met, which is firstly, it could not be said that the seventh defendant had published the articles innocently when the articles plainly referred to the plaintiff, and secondly, the seventh defendant had not made an offer of amends as required under Section 7, Subsection 2 of the Defamation Act 1957. So next, we can refer to one of our main cases, which is Dr. Clarence Edwin and another, and Harta Kumpulan Sedian Berhad and another, 2011. In the case, it was established and held that the statements did refer to the plaintiff. The impugn words were clearly targeted at Dr. Clarence Edwin, as his name was expressly mentioned in the letters. Thus, it was a case of direct libel and not in the form of innuendo or by implication. With these judgments, we may apply to our present case, which is Mazril clearly stated Vivy Yusof's name in his heading of the petition and caption. Namely, Vivy Yusof has to resign her position as board of directors UITM. And in the caption, he said, Vivy Yusof and a friend condemned the government's action of giving money to B40 and M40 families during the pandemic by saying the poor will get richer. So in conclusion, the second element for a defamation case is established as the words written by Mazlan were referred to Vivi.
So now I'll be talking about the third issue, which is whether the words published by Mazlan was communicated to a third party. Okay, so now I'll be talking about the rulings for this element. So one of the main cases that we'll be using is the Dr. Clarence case, which has been previously discussed. And in that case, they have discussed the third element that was established, which is there was publication of the statements. So in this case, the defendants addressed letters that they wrote containing the defamatory imputations against plaintiff 1 to third parties and carbon copied them to several others. This means that the essential ingredient of publication was firmly established. Furthermore, as argued by Plaintiff 1, the defendants ought to have known that the letters must have, in the ordinary course of things, been read by many others before or after reaching the hands of the addressees. There was thus present the likelihood of the publication not being confined to just the addressees or those to whom the letters were carbon copied, but being widespread. The writer, which is defendant 2, was actuated by deep malice in writing the letter speaks for itself. He didn't miss the opportunity to discredit and defame plaintiff 1. Moreover, the fact that there was a deliberate publication to a variety of persons appeared to be a planned and calculated move to cause optimum damage to plaintiff 1's reputation. He seemed serious and willing to publish the malicious words to all and sundry in blatant disregard of subsisting injunctions prohibiting him from doing so. So another main case that we are showing that we are using is the Stem Life and Matt Johnson nutrition case. Okay, and the case facts for this is that in this case, the plaintiff was a public company that offered cell banking services for future expecting parents, while the defendant was an owner of a website about infant products. The defendant published defamatory words against the plaintiff's business on the defendant's
Now, the
blog
judgment
and website. For this case is that the court concluded that the elements of defamation were fulfilled since the words published on the blog were defamatory. The words referred to the plaintiff and it was read by a third party. So the reason behind the judgment is that the defendant has stated that the plaintiff's business was unethical, incompetent, a greedy company, and neglects its own customers. As a result of the defendant's actions, the plaintiff suffered monetary loss such as the shares dropped and their value and reputation as a business was damaged. So moving on to the application of the case. So Mazlan, the defendant, published a petition online in order to bring down Vivy Yusof from her position as the board of director of UITM. This petition has been signed by over 30,000 people online, although it has been taken down since. So this is similar to the case of Dr. Clarence, where the letters had been published and read by multiple people. Additionally, the Stem Life case also applies to our case because the online publication had successfully reached the public and damaged the business and reputation of the plaintiff. Similarly, in our present case, even though only 35,000 people signed the petition, several others have read it because it is online, even though they did not sign it. Okay, another similarity in the Dr. Clarence case is that Mazlan had malice intention since he used the opportunity to further defame Vivy and encourage more hate for Vivy. It was a calculated and planned move on Mazril's part in order to cause optimum damage to Vivy's Yusof's reputation. Overall, the defendant's action fulfills the third element, which is it must be conveyed to a third party. If Mazril had not published the petition online and only communicated directly to the related authority regarding his concerns, Vivy's reputation may not have been so badly damaged in the public. The misunderstanding could have been cleared up easily with better and more responsible actions. So in conclusion, the third element of defamation has been established. So Vivy so what remedies can Vivy claim for this case? So Vivy can claim injunction and damages. So under injunction, she can claim to restrain Mazril from publishing similar libels against Vivy, against herself in the future. And the second one is that Mazril has to publish an apology and correction to the false statements and correct himself. And then under damages, in the Stem Life and Matt Johnson case, the court had awarded the plaintiff a sum of 250,000 ringgit for general and aggravated damages and stated that it is a fair and reasonable amount. And why is it a fair and reasonable amount? Well, in order to determine the quantum of damages, these factors have to be taken into consideration, which are the conduct of the plaintiff's position and standing in society, the nature of the libel, the mode and extent of publication, the absence or refusal of retraction or apology, and the whole conduct of the defendant from the time the libel was published down to the moment of the verdict. So Vivy should claim for general damages, exemplary damages, and aggravated damages because Vivy's Yusof reputation was suffered. And just to recap, the two main cases that we have used is the Dr. Clarence case and the STEM Life case, and these are the other cases that we have established in our presentation.
Okay, boss. It would be great if we can take the case.